but the session itself will actually be recorded. So the reason why we wanted to have this session is because when the eviction moratorium lifts, we expect a tsunami of cases coming into court. We're fortunate that the eviction moratorium has been extended till October, so we can still prepare. But this was one way that we wanted to help people in the community prepare, was by teaching you how to use MAID. We're lucky we have a great dream team to do the training. Quentin Stenhouse from GBLS formerly, who is now a clinical fellow at Suffolk, is actually the creator of MAID. And we have Stephanie Heron-Rice, who's an attorney with the Justice Center at Southeast, and Molly Lovell, who's a housing attorney with Northeast Legal Aid. So if you guys could just wave for a second, everyone could just see you. And what we're gonna do is, Quentin is gonna introduce this and tell you a little bit about how MAID was made, what are some of the features. Stephanie's gonna then do a 20-minute demo. Molly is gonna be on the chat, monitoring the chat. So as you think of questions, put them in the chat. We will then break after Stephanie's demo and we'll open it up for questions. I know it feels maybe hard with a group of 50 to do that, but let's just try our best to, Molly can help facilitate that through the chat, but also you can speak up about questions. If you could keep your questions general and not to specific cases, that is important for us. We're happy to talk offline if there's more specific questions. We did this training a couple weeks ago with about 80 people, and there was a really robust conversation and questions. So again, this is a chance for you guys to ask questions of the person who created MAID and Stephanie and Molly. So without further ado, why don't I turn it over to Quentin, unless there are any other introductory matters. Oh, I did forget one thing. In terms of the agenda, after the demo, what we're gonna do, and after the Q&A, we're gonna pause for a second and give you some updates about some of the advocacy efforts that we've been doing with the Housing Court around this whole new remote era as we enter it, because we wanna make sure that you all know what we're doing and also that we get your ideas to filter into this. So, Quentin, do you wanna take it away?
All right, so I think everyone should be seeing, let me just make sure, are you seeing just the slides right now, I think? Yes,
yep.
I think so.
That's right.
Okay, so today we're going to tell you a little bit about MAID, which, as Annette said, is a tool that I created at Greater Boston Legal Services, not by myself, with the help of lots of people, including folks at Mass Law Reform and around the state. So what is MAID exactly? It's a tool that I like to use the term a clinic in a box. So Greater Boston Legal Services for many, many years and other programs around the state have been doing these eviction defense clinics. And my thought was, how can we make that accessible to people who don't come into our office? So I was helping people off-site at Rosie's place. So that was one place where I wanted to be able to deliver the same kind of information to people. And of course, there are people who couldn't come into our office, people who had childcare needs, who had disabilities, and a host of other reasons why they might not be able to go to a clinic on one day, a specific day of the week, and during business hours only. What MAID actually does is it fills in the answer form, request for discovery, and up to 5 other forms. An example of some of the other forms includes a transfer notice if you want to move your case to the housing court. There's a provision for late answers, so it helps you file the motions you need that, and of course a request for interpreter. From the beginning, the thought was, how can we make this easy and accessible for people who have all different kinds of needs when they're coming in to start using the form? So we have it translated into 6 different languages. We thought a lot about what literacy level we wanted to target, so we're going for a 6th grade literacy level with all of the questions, all the writing, and that was one of the places that Mass Law Reform really helped quite a bit, actually, with getting the language just right. And then there are tools that help people with disabilities that you'll see as well. Why this matters right now, especially, is because of the pandemic. So I talked about general reasons why we want to have a tool that's online. here's a really specific one when people can't come in to be face-to-face with each other to help someone fill out this paperwork. And a tenant finds it challenging to get their paperwork filed in with the court. So what we've done with those questions is to make them, instead of being esoteric and legal, is to break them down into really simple fact-specific questions. This is an example of one of the things that you have to answer on the paper form, which is like, was the summons and complaint defective or was it served properly? Instead of asking that question, we break it down into the facts that someone can answer without having to understand what the law is up front. How exactly does MAID help with solving this scenario where suddenly you're an advocate and you have your tenant on the other side and you're split apart, right? Like, how do we bridge that gap that we have there now? Well, for one thing, it's available on a smartphone. So you could be helping somebody over the telephone while they're filling out the paperwork on their phone remotely, or vice versa. You can actually have this workflow, which is bidirectional. So if you're the advocate and you're talking to somebody and you're really experienced with using MAID, you might be typing the answers in as you go along. And then at the end of the session, when you've finished typing in all of the information that they've told you, you can send the form to the client to sign on their smartphone. And then you can continue to deal with the part of it, which unfortunately is still more difficult than it should be, which is delivering it to the court. So whether that's printing or using the Tyler system to upload it and e-file it directly with the court. So you and the tenant, if you're an advocate, never have to be in the same room to do this workflow. And of course, this is critical at a time when the court's closed for the most part. And I think that even after the court reopens, we know that there are going to be a number of steps that are different from what it was like pre-pandemic in terms of how often the court is going to allow you to be in the court, and the timing is going to be more confusing. So all these things that we can use to make it more accessible virtually are really important. For those of you who are coming from just the tenant advocacy side, you may be wondering why it's even important to do this. Why should we file an answer in discovery? And the first reason is something that Annette alluded to. This is a chance for the tenant to tell their side of the story, which is really important, so they can explain both why they shouldn't be evicted and potentially any defenses that they have to the eviction. And then they also have the right to ask for discovery, which MAID helps the tenant complete automatically. Discovery is your chance to get information to be prepared for going to court. So that's a really important right. So you don't want it, you're not, in Massachusetts, you're not forced to go into court blind, not knowing what your landlord is going to say at your eviction hearing. You have the right to know that up front. And that also has the effect of giving you time, because you do need time to be able to see what your landlord is saying and to respond to it and to think about how you're going to present your case in court. So in Massachusetts, you have that right to an additional 2 weeks, which is automatic if you've requested discovery. So everybody who uses MAID will have their hearing postponed by at least 2 weeks. We know that with COVID, the details of that might be slightly different, but it's going to be at least those 2 weeks. Currently, if you're using MAID in a one-on-one setting, what my experience at Rosie's place was that it took me about 20 minutes generally. It might take a little bit longer, especially if they're language translation, if you're going back and forth between the English and the translated version of the form, it may add some time, but generally between 20 and 45 minutes. And then someone who's doing it completely on their own might take 30 minutes to an hour, but that's time that they can be doing it completely independently at their own schedule. I like to tell the story of when we first added online intakes. So if you use MAID and you live in the greater Boston area in GBLS's service area, it actually will deliver an intake to GBLS as well. When I turned that feature on, our very first intake came in at 12:30 in the morning. So that's the time, there's no legal aid office that's open at 12:30 in the morning. But that person really needed to solve their problem right then at that moment. That was the time they could do it. Whether it was emotional reasons or timing reasons because of the work, I don't know. But it was great to be able to see that that was how it was being used. Stephanie's going to go into more the demo and the training part of this next, but just to give you a little bit of context for how you would use this as an advocate, one of the first things that you would want to make sure is that your client has gathered all of their documents. So this is a picture of the two critical forms. One is the notice to quit, This is an example of one that's for non-payment of rent on the left. And then of course the summons and complaint, which is the paperwork that tells the tenant to go to court at a specific date and time. So it's very helpful if the tenant has these two forms with them when they are using MAID, because there's a lot of questions that are better answered if you have them in front of you. If you don't, it's still possible to use it, but it's going to rely more on your memory of those things. If at least you've seen them and you can remember what's on them, then you'll be okay as well. Then the workflow that you would have is to actually start filling out the forms. I'm hearing a little echo, so I think somebody might not have been muted. Okay, it's already been solved. As I said, you as the advocate could be working on the computer, and then there's a point at which you can send the form to the tenant to sign remotely. And then finally, this is where I think the tenant's going to have the most challenge, is when it comes to delivery to the court. We're still hopeful that there's some new ways that the court will agree to allow us to make this easier. Those are not set right now. So you would most likely want to download the paperwork at the end and then upload it through the Odyssey file and serve system that's created by Tyler. So this is the Massachusetts e-filing portal that you would use. At this point, I'm going to turn it over to Stephanie to do a demonstration.
Hi everyone, my name is Stephanie. I work at the Justice Center in Brockton, and I'm gonna probably very clumsily walk you through a MAID interview beginning to end. There's some construction going on in my house, so somebody wave their arms if you can't hear me or hear the background too much. I'm gonna start.
Stephanie, you're good.
Awesome. I'm gonna start by sharing my screen. There we go. So a quick Google search of MAID eviction MA. I do not want to know how to evict a tenant in Massachusetts. Pulls up this website, which is how you access MAID. You click start the online form, and that brings you to the online form. Something I want to highlight is everything that is written on the screen can be read out loud by this cool tool up here. Something else I want to highlight is language. You can change the language in the interview up here to all of these at any point. You can also sign in to save your answers. So that's a cool little feature. You can go in and your work is saved once you sign in. You can also share interview by entering a phone number or an email there, and that allows the back and forth that Quentin was talking about. Okay, so let's get started. Again, this talks about the timing. Anytime you see something in green, there's a really cool feature that if you click on it, you get a picture, you get a sample, or you get more information, which I really like. Let's continue. Who's completing this interview? Either an attorney or a tenant or helper. For the purposes of today, we're going to do tenant or helper. And just walking through what the interview is, what questions they're going to ask, that kind of thing. So you should mark any facts that are true, even if you don't think they're related to the eviction, etc. So there's this really cool feature. How many times can you say that over? Of really helpfor video tutorials throughout the interview. So this one is, I think, about a 6-minute video that just walks people beginning to end for the eviction, through the eviction. So continue. Upcoming court dates. Do you have a court date coming up for your case? Yes, I have a court date scheduled. If you click the other ones, I missed my first court date, or I have an agreement already, it won't let you proceed, or it will let you proceed with a motion to file late answer. Okay, so what's your current address? Let's say 62 Main Street in Brockton. That's Plymouth County. My phone number is this, and my email address. There we go. Is this also the address you're being evicted? This is critical because the court will communicate with tenants at this address. So, so you should always mark if it's not that. That also flags for defects in the summons. Oh, yes, it is. Continue. Again, What is your name? Continuing on, and Quentin, it's very, very anxiety inducing to walk you guys through this when the creator is right here. So please feel free to jump in at any moment. Is there another tenant with you? No, it's just me for the purposes of this. Again, does the line to defendant, tenants, occupant contain something in addition to Stephanie Heron Rice? No, it's just that. If I say yes, that will flag additional, that will flag some defenses relating to the summons and complaint. So, and it'll also have other people be able to sign as well. Does the line continue? Okay. So this is also a really cool feature of MAID. It reminds folks of deadlines coming up in their case. We want to flag that, you know, we are in COVID-19 with COVID-19 in very unusual times. So you always want to call the court and make sure that your deadlines are actually your deadlines and that your scheduled court date is actually your scheduled court date. So some information about your landlord. Let's say my husband is evicting me. Let's not tell him. Continue. And then my landlord is a company or corporation. Some more facts about your landlord. So I'm gonna, again, try to switch the language into Spanish to see how we do with that. And then the whole thing just turns into Spanish. These little question marks tell you more information. So this says, podría incluir LLC. So that's telling you that your, if your landlord is an LLC, something that might signal that's the case is the word LLC in the top of the summons. If it is a trust, it might include realty trust. So it's peppered with really helpful hints throughout the interview. So let's say, I don't know. So if your landlord is a company or LLC, it'll say, does he have an attorney? That'll flag a possible defense. We're not going to get into the legal background because the cool thing about MAID is that you don't need it, right? It's transforming common English verbiage at a 6th grade level into legalese, into a legal form to defend against your eviction. So none of the above, or I don't know. Let's keep going. Does your landlord have an attorney? Let's say if yes, it's going to ask you for the attorney's name, zip code, etc. And it's also flagging for, like I said, searching for defenses. I'm going to say no, he doesn't have an attorney. And it automatically picked out Metro South Housing Court because I put in a Brockton address. But you always want to check in the summons and complaint in green. We get a sample. Whether that's the court you're going to get. If you get a district court, it'll prompt you to do a transfer, okay? So what's the date of your court hearing? This is typically found at the bottom of the summons and complaint down here. Can you see my cursor? I hope you can see my cursor. Anyway, what is the date of the first court hearing? So we're gonna say it's on the 24th with my answer due on the 17th. Continue. Again, if you sign in or you register, you can save these so you can go back and edit them. So some more information, you're hearing, this is what I want to flag, COVID-19 emergency, your hearing might happen at a different time, please call the court. Okay, let's continue. The reason for your eviction, look at your notice to quit. Again, a really helpful sample. What does your notice to quit say is the reason you're being evicted? If you owe rent, it'll typically be for 14 days. My landlord says, again, no legalese here. This is simple English or whatever language you choose terms. My landlord says I did something wrong other than owe rent. For example, a noise complaint or damage to the apartment. My landlord doesn't want to rent to me for something other than I didn't pay rent or something I did. So my landlord wants to rent to a family member, that kind of thing. Let's say you owe rent. Continue. The main reason my landlord says they're evicting me is non-payment of rent. And that just gives you more background into what that means. Information about you and your family. I live in public housing. If you click English is not my first language, you will be prompted to ask, the system will prompt you if you need an interpreter. Once you click I need an interpreter and a language, it will automatically create a request for an interpreter form, which is really helpful. It'll be a PDF that goes right along with your answer and discovery documents.
Stephanie, can I just add something?
Sure.
I think that this is a really important point because what we are seeing is that tenants are not getting access to interpreters when they need them. And so what MAID does is it actually builds it right in. So this is, to use Stephanie's word, a really cool feature.
A really cool feature indeed. So coming through, it says somebody that lives with me has a disability, somebody's under the age of 6. These again are also flagging for different defenses and or stays, availability of stays. So let's say your landlord is a housing authority, or you can say you don't know. For the purposes of today, let's say it's a housing authority. So when did you move in? Best date you know. I always say if you don't know, if you know that you moved in around June, but you don't know when, click the first. How much do you pay for rent? Let's say 500 because we clicked it's a subsidized unit with a housing authority, and that is monthly. And my rental agreement is, let's say you don't know. It'll say a lease, a month to month. I don't have one. Say I don't know. Keep going. So it automatically populated a 14-day notice to quit because you set non-payment. If that's not the case, you can switch it. You can also click you never got it or you don't know. Let's keep going with our 14 notice to quit. Again, here we get the notice again, which is a really, really helpful thing. The notice to quit includes the name of everyone who signed the lease, yes or no. If not, this again is flagging for defenses. The notice to quit has the correct address. If no, again, this is flagging for defenses. The notice to quit leaves out language that is required by my lease. So let's see what this says. Answering this question probably requires the help of a lawyer. You can leave it blank if you're not sure. Okay. I was behind on my rent when I got the 14-day notice to quit. If that's the case, yes. If not, then you can click something else that again goes to defenses against the eviction. So I offered to pay the full amount of money, or I gave my landlord the full amount of money, or I never agreed, etc. Timing of the notices. When did you get the notice to quit? So I said we were going to court on the 24th. So let's say we got the notice to quit on June 20th, on July 20th. Find the line on your summons and complaint that begins with because. Does your summons and complaints, what does the summons and complaint say is the reason for your eviction? Does it match the notice to quit? Again, this is going to the sufficiency of the notice, defects in the notice and the summons or otherwise. Summons includes the names of all the adults who signed, and it has my correct address. And this is populating with the information we already answered before. So was I served properly? This is one of these really, really helpful videos that just walk you through whether you were served properly. Something we hear often is, how can I possibly have been served properly when the landlord left it under my door? This goes through what constitutes proper service. So you can know a little bit more about your rights. The date I got the notice to quit, I inputted before, and it's automatically populating it here. And the day I got the notice to go to court was, let's say, on the 10th. Someone handing it to me, it was mailed to me, or left in my apartment door. Which one was it? Sometimes it's both. Let's say it was mailed to me and it was left at my apartment. Taped to the door. Ooh. Okay. You may have a right to stop the eviction if you paid all the money owed no later than 10 days after you got the notice to quit on July 30th. So it automatically calculated this date. And that information would be different regarding, depending on what I answered for was the terms of my lease, and the timing of the summons, and of course the reason for the eviction. So I paid the court costs, I paid all of the rent, I paid the court costs. That's going to populate a defense to the eviction. And this is the first time. The date I paid my landlord was, let's say I paid him on the 29th. Continue. Okay, so now this is screening for waiver, which is another defense to the eviction. It explains to you a little bit more about what that means in case, this is really helpful when it's a tenant completing it by themselves or when it's an advocate who is not an attorney. So I paid rent after July 20th. I signed a new lease or none of the above. Let's say I did not do that. Or let's say I did. Does the notice to quit says rent will be used for use and occupancy only? If it does, then the defense might not be available to you. If it doesn't, the defense might be available to you. Let's say no. Continue. You may have a defense. The landlord might not have followed all of the technical steps to legally evict you. So let's keep going. Now, information about the unit. Has my husband tried to lock me out? Well, let's not call him my husband because that's not legally correct. But has my landlord tried to lock me out? Has entered my home without permission? So this is prompting tenants to say, again, screening for defenses. So let's say he locked me out and I paid security deposit. Continue. So this is populating the defenses that are relevant to my specific case. I said I had subsidized housing, and that the housing authority was my my landlord, and so that's why these defenses are populating. Ooh, something happened. So my landlord does not have cause to evict me. These are common defenses related to subsidized housing. I never offered a chance to discuss in private, or there's a VAWA defense there, the Violence Against Women's Act. Again, more subsidized housing defenses. A portion of my rent is paid by a housing authority. They stopped payment due to bad conditions. Let's say my rent share was improperly calculated and my landlord was taking side payments, which, depending on what information I said about my house, might populate further defenses relating to consumer protection law. Let's see. Bad housing conditions. List any problems with your apartment as you live now. This is another one of those really helpful videos that says, that walks people through having to take pictures of the conditions, documenting them, bringing everything to court, that it's not enough to have it on your phone, et cetera, et cetera. So it's really helpful. So let's say I have cockroaches, I have mice, and I have a defective or leaky window. Continue. So, did you tell your landlord about the housing conditions and how? So let's say I told him over the phone and the conditions existed when I moved in. Repair and deduct. In some cases, if you made your own repairs, your landlord may be liable for the cost. Did you pay your own repairs? Let's say no. Retaliation. There is another helpful video around retaliation that I am not seeing, but I'm sure it's going to pop up soon. Again, we have this little feature that if you need anything read out loud, it will. So retaliation, what that means. Did you take any of the following actions? I report it. So it's already, it has some already marked, right? Based on my previous defenses, on my previous answers. So let's say I reported bad conditions orally to a public agency and in writing to my landlord. And if it happened in the past 6 months, this is important because of the presumption of retaliation that the landlord will then have to disprove if it was in the past 6 months. Protected classes and discrimination. This is a video that explains not everything is discrimination, not everything is a protected class, and goes through what kinds of discrimination are illegal. And so not wanting to rent to children, not wanting to make changes, treating someone unfairly because of their status as a protected class. So do you have any reason to believe that your landlord is discriminating against you? Let's say no. Breach of quiet enjoyment. A breach of quiet enjoyment, again, explains it in very simple, easy to follow language. Think about the problems over the past 4 years and select any that apply below. I already said he locked me out of my home, and I already said I had bad conditions, so those are pre-marked. Interfered in some other way. You can write that in. So I've already clicked in the past that I paid a security deposit. So now it's asking me further details on that. So let's say I paid $500 because that's my monthly portion of the rent. And then what did he do? Did he not take responsibility for something I paid a former landlord, or didn't give me a statement of conditions, no receipts, separate bank account, etc. Let's say. And consumer protection law is another thing that another defense that might be available for people, for tenants, and let's say I was charged an amount of rent that I did not agree to pay. So this is a very important screen because it walks tenants through what is a jury trial and should they keep their right to a jury trial. It talks about, you know, you getting more time to find a lawyer if you ask for a jury trial, and how it can always be waived at a later day. But you can't get it back once you waive it. And so in general, tenants are on the side of keeping their jury trial for many reasons that we won't get into today. Important to note that you can still reach an agreement with your landlord. Most cases end up with an agreement, whether or not you choose a route to a jury trial. And this does not mean that you'll have to stop paying rent. So on the cons, we have that they're complicated, that, you know, you might need a lawyer for it, etc. So you can keep it or give up my right to a jury trial. I'm going to keep my right to a jury trial. Requesting time to move. We don't know yet who will win your case. If your case goes to trial, the judge or jury can decide in favor of your landlord. You might get more time if you are over 60, up to a year, or it calls for you in your own words to explain any special circumstances you want the court to consider when deciding to give you more time. So this is a big one. If you have an IEP at a local school district, you know, I have clients that put in, you know, I'm a single mom and my family lives in this area and I can't afford another apartment in this area, that type of thing. Anything you want the court to consider about your situation. And so you've now finished the main interview and there's just a few questions left. If you need to change anything, you can go back and say, oh, I remembered my landlord has a middle name. And now I put it in. So let's go back. Resume. Almost done. And again, if you sign in and register, you can close this, walk away, come back at a later date and finish it up. So in the same way that the defenses and claims were automatically generated based on my previous answers earlier in the interview, your discovery requests, which is the questions you are allowed to ask of your landlord and proof of their case that you're allowed to ask your landlord, are automatically populated. You can either keep those default selections or customize discovery and go through and click what questions and production of documents you want from your landlord. It's in my experience, the default selections are really good in MAID. In terms of discovery, they're broad, and so I'm going to keep default selections. So filing discovery is what gets you a 2-week continuance in your case to allow for that production of documents and for your landlord to answer the questions that you have about his case so that you as a tenant can be better prepared on that first court date. Okay, so now that we kept the discovery default, you're ready for signing. So if you are an attorney or an advocate, you can share the interview for signature on the client's own phone. The client can either open their camera on their smartphone and point it at this, and it'll automatically populate, or you can email or text them a link for them to sign and get back to you. You can also sign it on your phone, sign on the computer, which is what I'm going to do, SHR, or sign it on your phone. Then it asks you how you're getting the paperwork to your landlord, and it flags that you need to do that no later than August 17th. So I'm going to say I'm going to mail it. Note that for email or fax, you need the permission of your landlord. So I'm going to mail it to my landlord, and I am saying that I'm going to mail it today as soon as we're done with it. So continue, and this is a really cool tool as well, where if you click it, it shows you legal services program that covers your area based on the address you inputted before. So let's do continue. And it's thinking. My internet is a little slow today. So it's thinking. Oh, no watched pot boils. I have a lot of trouble with American sayings, but I think I got that one right. There we go. You finished the interview. What do I do with the answer? This talks about filing it with the court and serving it to the landlord. Again, another helpful video. So you can either print your forms and file them today, or download a copy of Microsoft Word format to edit. I think this is a really good feature now that we are in COVID times, because we don't know a lot of times what the trial date is going to be for clients, or people have summons that now, given the moratorium, are kind of caught in limbo. So this allows us to pre-make these answers and discoveries, and then go in and change the dates as we know them, as we learn them. So looking here, this is this really cool first page that has a lot of important information: when to go to court, September 7th, arrive by 9, what to bring to court. Again, I want to flag that we are living in very different, not normal times. And so you should always call the court and not rely on this during these special times. So this is a cover letter for the court saying that this includes my answer, and this is everything we did to. So my name's Stephanie. I live at 62 Main Street. I pay $500 in rent. And then all of the defenses that it flagged. So it failed to comply, not properly terminated because I said I paid my landlord rent, right? And that it might have been recreated, the tenancy have been recreated. They failed to comply with subsidized housing rules. They might have retaliated against me. There's bad conditions in my home, etc. I do want to point out that here is my signature and the notice of interpreter request. I requested a jury trial, and I requested a interpreter in the Cape Verdean Creole language, and that is in with the court now. Also, my discovery dates. My discovery form is here with instructions for the landlord, definitions, and then the questions about the tenancy, the landlord's claims, etc. And then I think there should also, document requests are also in here. And I think there should also be, yep, there it is, a separate form for notice of interpreter request. So this is the same thing that would, if your case is filed in district court and the system prompts you to transfer it to housing court, or asks if you want to transfer it to housing court, you will get a separate filing saying notice of transfer with instructions of what to do with it. So that's made.
Stephanie, amazing. You know, Stephanie is, it went fast. You did a great job.
Yes.
Lots of content. And as you
lots of content, and I'm sorry for speeding up too much.
No, you, and Molly, I'm going to turn over to Molly to begin to field questions, and let's open it up. You know, we've got about 50 people on the call, but really, and I'm going to stop recording. I say that, stop.